File 25-93252FH. It's on our docket for a sentencing and also a show cause, but I think I dismissed that show cause, so that should have been off the docket. So we'll do just for sentencing. Possession methamphetamine. Mr. Vogler, have you had a chance to review the pre-sentence report and recommendations with your friend?
Yes, I have.
Any additions?
Welcome back to the channel, folks. Today, we're diving into a jaw-dropping Michigan courtroom case involving meth possession, a plea deal, and some heated fireworks you will not believe. From legal battles over sentencing guidelines, to emotional pleas and even a contempt of court outburst, you're about to see how a simple possession case spiraled into courtroom chaos. Stick around, because the ending will leave you stunned.
0 to 11 months, any scoring challenges?
Here the judge brings up the sentencing guidelines, 0 to 11 months. That's the advisory range based on Michigan's scoring system. But here's the kicker. Even though the range looks light, prosecutors are already pushing for more points. On the record. Question for you. Do you think prosecutors should be allowed to stretch scoring rules to maximize punishment, or should they stick strictly to the book?
Felonious criminal acts involving other crimes that were committed. The PSI scored OB12 at 1 point. The people would assert that it should be scored at 5 points.
The fight over OB12 begins. Prosecutors want 5 points instead of 1, claiming 2 separate felonies happened: delivery of meth and using a computer to arrange it. The defense argues they're all part of the same act, not distinct crimes. This might sound technical, but the stakes are high. More points can bump sentencing ranges significantly. This is classic courtroom chess. What's your take? Should texting someone count as a whole separate felony act?
From the defendant's residence. At that location, the CI.
Sure. Well, I think that the delivery is the basis for scoring 1 point for one.
Okay.
Contemporaneous felonious act. That there was another delivery, right? Or the delivery. But what about the? Isn't using a computer to commit the crime the same act?
Well, in this case, prior to the delivery occurring, the phone was used, Facebook Messenger and phone placed between the CI and the defendant to arrange the meetup location for the delivery.
Mr. Vogler, your position?
Your Honor, I was assuming they were using the dismissed computer charts scoring for point 1, for the 1 point, and trying to use the delivery. I think it would be barred by the holding of People v. Light, which was decided back in 2010 at 290 Mishap 717, picked up again by People v. Carter 503 Michigan 221 2019. And just to quote a little bit from the Supreme Court case, they indicated that
the defense isn't backing down. They cite Michigan Supreme Court cases, People v. Light and People v. Carter, arguing that you can't double dip and call possession and delivery separate acts when one is just part of the other. This is brilliant. Legal strategy, using precedent to shut down prosecutorial overreach. Ever wonder how much case law actually protects defendants in real life? You're watching it in action.
Well, 2 things have to happen for it to score. The criminal act must have been contemporaneous, that is, within 24 hours. And the criminal act will not result or has not resulted in a separate conviction. Here, illegal possession of methamphetamine is a necessary included lesser offense of delivery of methamphetamine. That, I don't believe you can use the illegal possession twice to gain another act under OB12.
What about the computer crime?
That one is so.
Because I see the prosecutor's point that she used the computer device prior to, so you could chronologically separate it out a separate act. But what would make that act a felony by the charge is used a computer to commit the crime.
The only way that comes into play is, and it's really a tough one in my mind, but I'd always assume that the computer using it would be in situations such as looking at storing, retrieving, sending child pornography, using it to steal identity, using it where the action of using the computer is actually the commission of the crime in question, whether it's fraud, identity theft.
The judge raises an interesting point. Using a phone or Facebook Messenger to set up a drug meet isn't really the kind of computer crime the law had in mind. Think about it. Laws meant for identity theft or hacking now being stretched to include texting. That's why he says OB 12 should score 0 points. Viewers, do you agree with that call? Or should arranging a deal online be treated more seriously?
In and of itself.
All right, Mr. McLennan, any rebuttal argument?
No, Your Honor, I think I covered it already in my previous comments.
Okay, I think OB 12 is designed to cover separate felonious acts. And here we have really one act is arranging for a delivery and making that delivery of meth using a computer device. It resulted in 2 separate charges using the computer and the delivery. But then it was pled to a single felony of possession, which is a necessarily lesser included offense of the delivery. And the use of the computer was all wrapped up in that same act. I don't really see that there was a separate felonious act committed. So I'd actually score OB 12 at 0 points. All right, Mr. McLennan, you had a challenge on OB 15?
Yes, Your Honor, the offense involved the delivery or possession with intent to deliver.
Next up, OB 15. This variable adds points if the crime involved delivery or intent to deliver. The prosecution pushes for 5 points, saying there's evidence of actual delivery. Defense fires back with People v. is Gray, arguing you can't count, dismiss charges or other conduct. This is where plea bargains get messy. Should prosecutors be allowed to resurrect dismissed charges at sentencing? Or is that fundamentally unfair?
Which I kind of just rely on that again and believe that that should be scored at 5 points.
Thank you, Mr. Vogel.
Would ask the court to continue that score of OB 15 at 0. I'm relying on People v. Gray. That's a Court of Appeals case in 2012, 297 Mishap 22. I thought the holding there in that case involved, if I recall correctly, a gentleman with a quantity of methamphetamine in a motel room. At the same time, he had a quantity of methamphetamine in a vehicle that he was driving when he got pulled over. He got charged on and convicted of what occurred as to the meth that was in the vehicle. The quantity that was in the motel room, that separate charge, but case prosecution wanted to get more points based on the quantity overall, possession quantity, adding to it what was in the motel room. And Gray said, no, we're only going to look at this offense that the court has before it. And denied that, and that is how it stood. I think the Gray comes down, there was a People v. Drake, it's an unpublished case, but I thought it sort of summarized Gray pretty good. And if I could just read it slowly to the court, because it's quoting right out of the case as it is. OB 15 requires a court to separate the conduct forming.
Listen closely here. The defense hits the heart of the issue. You can't let prosecutors drop a charge in a plea deal, then bring it back to punish the defendant during sentencing. That's like saying, we'll give you a deal, but secretly, you're still paying full price. What do you think? Fair play or foul play?
Resulting in dismissed charges that are not part of the sentencing offense. And assessing points for OB 15 because it would be fundamentally unfair to allow the prosecution to drop a charge while brokering a plea bargain, then resurrect it at sentencing in another form. And I think here that OB 15 is very tightly drawn. This is the sentencing offense. This is what we look at. And there's no delivery in the sentencing offense. Nor could you argue that the amount possessed or was under circumstances of trafficking, because this is a one deal situation. There's no evidence of any trafficking, and which is, by the way, defined by the statute governing OB 12 or OB 15.
Yeah, there wouldn't be evidence of trafficking
No.
here. Mr. McLennan, any rebuttal argument?
No, Your Honor, just that I think there is evidence of additional conduct past just rather.
Okay, well, the language of OB 15 counsels to score 5 points if the offense involved the delivery or possession with intent to deliver marijuana or any other controlled substance. Then there's the separate part, or possession, where there's...
The judge makes a nuanced ruling. Even though the conviction is just possession, the act itself involved delivery. So he gives the prosecution their 5 points. But here's the twist. It doesn't change the sentencing range. Classic case of a win that's not really a win. If you were the prosecutor, would you celebrate that or feel like it was wasted effort?
But the Supreme Court has held that trafficking only applies to possession, not to the delivery or possession with intent to deliver. And here, the language of the guideline is the offense involved the delivery or possession with intent to deliver drugs. Not that the offense was delivery or possession with intent to deliver. So the involved is broader language. I think that means that where there is a delivery and it's pled down to a possession, that then, I mean, the prosecutors, or I'm sorry, Mr. Vogler's right, that People v. Gray says that OB 15 is a McGraw variable. But the language of the statute is that it involved. In that case, that was a possession case that they were trying to look at other drugs that were dismissed. You know, there's one event, there's one, as I just said on OB 12, there's one felonious act. And that act, sentencing offense is possession, but that act was the delivery. So that this possession did involve a delivery. So on the basis of the statutory language, I would score OB 15 at 5 points. So that brings the total OV at 5 points. It still is OV level 1, so that doesn't change the range. All right, Mr. Vogler, anything you want to say on behalf of your client?
Oh, yes. Your Honor, it seems to me, based on everything that we know about this case, is that
Now the defense humanizes the client. They argue this was a one-time slip, triggered by a police-controlled buy. The client had been in recovery for years, refused other attempts to sell, and wasn't a dealer. This is where law meets humanity. Should courts weigh personal recovery stories more heavily, or stick strictly to the cold facts of the crime?
Valve, she was a friend of my client's. My client, in her words, helped her out. So that happened. It happened on March 6, 2024. The police approached my client, about 5 months later, on August 28, 24, to interview her to see if she would want to work for the police. And my client's response really was to the effect, like, I'm clean. I've been out of that. It would look really funny for me to go around and approach people to buy something when I'm out of it. And there wasn't a warrant authorized till November 5th of 24. She wasn't arrested until February 11th, 2025. And so here we are today. I know that from the information I've received, candid information that the officer in charge of this offense did not believe my client was a drug dealer. I don't think she was in their sights. She's been in a methadone clinic for the past 8 years, working her way down slowly from the quantity of the dose that she receives. She hasn't had any problem since almost a year and a half ago on this. I believe that there were attempts to come back after that March 6th to make further buys, which did not happen. And that there were requests before that date by the same person that did not happen. So this is a situation where we asked for, and there's been an agreement upon with the prosecutor, the disposition under 7411. I think my client confident she's going to be able to successfully complete that. I think she intends to go out and look for work. I think she's put that off because of this thing that's been hanging over her all this time. And probably that'd be one of the better things she could do is to go out and have work, get her out from her house, expand her life out a little bit more. But ultimately it comes down to this, in my opinion. This doesn't happen but for a controlled buy being made on her. It just doesn't happen. Not that she wouldn't have gotten caught, but there wouldn't have been any uncaught sales. That's all I'm saying.
Okay, thank you, Mr. Burke. Ms. Parr, you don't have to say anything today, but it is allowed. Is there anything you want to tell me?
Not a very good speaker. I do want to say that I have drug students here since 2016. I've been in recovery. And that's where I plan on being. That's what I want. This shouldn't have happened. It was a slip and I'm up stronger than ever. I'm too old for this. I know what I want in life. And it's been recovery. That's it, Your Honor.
What was going on with that meth use?
The judge zeroes in. If you had meth to deliver, you must have been using. The defendant admits yes, she was. This is a pivotal moment. Her honesty makes her vulnerable but also credible. Many judges punish denial harder than mistakes. Quick poll. Do you think admitting drug use helps in sentencing, or does it just seal your fate?
Using with her, it wasn't happening until she came around. I thought I was strong enough in my recovery to help somebody out. She was doing good for a long time too. So it was something I was trying to help her out of, help her with, and I just got sucked into it. And
Your Honor, could I
No, Mr. Parr, you don't get, Mr. Parr.
Whoa, courtroom drama explodes. The defense attorney interrupts, and the judge immediately holds him in contempt. 1 day in jail. Then when he protests, it jumps to 48 hours. That escalated fast. This shows how tense these hearings can get. Should judges be this strict about interruptions, or was this an overreaction?
4 hours in the Prescott County. The court will prepare a judgment.
I was getting respect.
You want more time to keep talking? If you keep disrupting, you're gonna get more
Can you
time.
respectfully talk to me?
48 hours. 48 hours. Continue direct contempt and interruption report. Mr. McClellan, recommendations?
Thank you, Your Honor. Ms. Parr is 41 years old, 7 prior misdemeanors. It looks like this would be.
The prosecutor strikes a balanced tone. Yes, meth is dangerous, but the defendant shows potential and should get the 7411 deferred status. They suggest a short jail stint, leaving the length to the judge. Notice the contrast. The defense painted her as fully redeemable, the prosecutor as cautiously optimistic. Who do you think made the stronger case?
Your Honor, on the flip side of the coin, methamphetamine is a destructive substance. She was facing a 20-year felony in this case. plea was a huge benefit to her. And we are recommending the 7411 status, but the people would still ask for a short stint in jail, Your Honor, and would leave that amount of time in the court's discretion.
Can I ask you, Mr. McLennan, so, you know, I get a summary of the offense in the pre-sentence report, but I don't have the full benefit, and nor should I, of course, of all of the investigative materials that you and Mr. Vogler has. So when Mr. Vogler says, as he reads this, that there were approaches made to this defendant by the same CI before and after this delivery, and there were refusals of this defendant to facilitate that, and this was the single yes in a series of no's. Is that correct?
I
As you
don't
understand the material.
I don't believe I saw that in the police report, Your Honor. That would be news to me. So I'm not aware of that.
It was our position, Your Honor, and that's a position we took in our motion on it.
Yeah, which is part for your benefit. I mean, I know you're distracted by that.
I'm so sorry.
That doesn't
You're right.
doesn't affect what happens right here with you. Okay, it's totally separate. Just for your benefit and perhaps peace of mind, as your attorney outlined that in a motion, that was going to be a heavy lift and probably not successful deliveries where somebody's, you know, cajoling somebody to deliver and they finally do. That's very rarely going to be an entrapment. Maybe if it's like, gee, I'm dying of cancer and I need you to give me some of your pills, sort of thing. But methamphetamine doesn't have any of those type of.
Helping nobody.
Right. All right, but that's a relevant context for the court to think about. So here in this part, we've got, you know, one case, this is a simple case controlled by a meth. You know, we get these all the time. But this is not, there's some complicating facts here, one of which is this would be, if you were convicted of delivering methamphetamine, I kind of did a thumbnail on the guidelines, and you'd be looking at 24 to 40 months would be your guidelines. Right? So that event, if you were convicted as charged, would be the lowest sentence you'd get would be 2 to 20 years in prison. So you got a significant benefit by a reduction to possession. So you're.
The judge breaks it down. Without the plea, she'd be facing at least 2 years in prison, up to 20. Instead, she got probation and the chance to erase the felony. That's a massive break. But the judge also reminds her she's been given second chances before, and they didn't always stick. This is classic tough love sentencing. Should prior failed chances weigh heavier than current progress?
To be accurate. But then, you know, and on 0 to 11, I'm directed by the legislature to consider no jail unless there's reasonable grounds for some incarceration. Here I look at, this was pled down from a delivery, which would have been prison. And also when I look at your misdemeanor history, I do see where you've been given a lot of chances, and maybe that's caused you to not fully appreciate the seriousness of some things. Your criminal record is an embezzlement where you got fines and costs, a misdemeanor. A misdemeanor bad check case, fines and costs. A misdemeanor no security, fines and costs. A misdemeanor drunk driving with a child, 15 days jail. Shoplifting, 15 days jail. A second offense, drunk driving, 5 days jail. A DWLS, fines and costs. You did get an unsuccessful discharge from sobriety court and 180 days in jail in 2016. So, I mean, I do think that there's some incarceration that's appropriate. The question is how much. So taking all these things into account, this part, I am going to place you on probation for 24 months.
Here comes the sentence. 24 months probation under 7411 status, plus 6 months in jail, credit for 2 days served. Financial costs added on top. This is middle-of-the-road sentencing, firm but not crushing. The judge clearly wanted accountability, but also gave her a lifeline. Do you think this balance was fair, or should it have been harsher or lighter?
And I'm going to order that you serve 6 months in the Presque County Jail. Give you credit for 2 days previously served. That is a sentence within the advisory guidelines, around the middle of it. I think as I outlined, there are some reasonable grounds for incarceration. This would be a prison case to possession. And it does have a history of misdemeanor criminal activity. As part of this, the sentence of the court, if you have to, within 24 hours of your release, you have to report to your probation agent. If you wanted to appeal, you can do so by filing an application. If you want a lawyer, I would give you one, but you'd have to ask me within 6 months. So we're going to hand some appeal paperwork to you. Ask you to initial one copy for us. Fill out the other one if you want to take an appeal. And good luck to you, Ms. Partner, on the 7411.
So, to sum it up, a possession case rooted in a controlled buy turned into a heated courtroom battle. The judge rejected overreaching guideline scoring, acknowledged the defendant's struggles and progress, but still imposed jail time to drive. Home accountability. Meanwhile, her attorney ended up in jail for contempt. This case shows just how much strategy, precedent, and even courtroom temperament can shape justice. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.